Hello, everyone. Very honored to be here. I am either the last page of a long homework assignment or the long-awaited band in a concert the feature band. You can let me know which one you think I am. All right, like I said, very honored to be here, really enjoying the experience. I am going to connect, hopefully, inshallah, God willing, all of this to U.S. Muslims and U.S. politics right now. So what we heard, the midday presentation was a lot about Sharia and Islam in Muslim majority lands, right? Not what goes on when Muslims are living as minorities in a non-Muslim land. And so there's a lot of, Nastana just went through a lot of the fear of, does this mean Muslims are some kind of a sleeper cell, that we don't owe any allegiance to the Constitution? And that's where a lot of the fear that she was describing is coming from. And I want to point out something really, really clear in the Sharia that is often lost on that specific topic, which is the Sharia itself tells Muslims to follow the law of the land where we live. That includes when we're living as minorities under non-Muslim rule. And this goes all the way back to before there was a Muslim government. Muslims, when they were being persecuted in Mecca, Prophet Muhammad, peace be upon him, sent them to live under the protection of a Christian king in Abyssinia. So Muslims have lived as minorities in non-Muslim societies for a long time. So we know how to do that, right? We're told to do that. The only criteria of what to do in that situation, you follow the law of the land unless you are being forced to do something that is mandatory. Remember the 5 categories she just did. If you're being forced to do something that is mandatory in Islam, or on the contrary, if you're being forced to do something prohibited or required to do something I'm mixing this up, required to do something prohibited. So if you're being forced to drink wine, or if you are prohibited from doing something that is mandatory, so you are prohibited from prayer. In that situation, the scholars mostly said your obligation is to leave. Notice it is not to take over and change the law of the land. It is to leave, to go to a place where you are safe to practice your religion. This becomes very important in lots of moments in Muslim history. For example, the Crusades, when many generations of Muslims living under Muslim rule suddenly were under Christian and very oppressive rule in Andalusia. Luckily, in the United States, the Constitution does that for us, already protects our free exercise. So not only, as Dahlia told us yesterday, protecting no religious litmus test for the president, we also have a First Amendment that protects free exercise of religion. So we're very lucky to be in a place where that concept is built in. And it comes up in everyday life. We have lots of situations where everyday Americans are asked to accommodate for religious practices. Every year I get a note from the university reminding me that Jewish students will not be able to take exams on Saturdays and to make an accommodation for that sort of thing. So this happens all the time, from flipping the practice schedule at Fordson High School in Michigan because almost the entire football team was Muslim and it was Ramadan and they were practicing, they practiced at night so that the football players could practice properly. And this, of course, became a big to-do. It's Islam, Sharia is coming to Michigan, Anyway, but lots of situations where people will voluntarily accommodate like that, sometimes ask for legal accommodation. What I'm going to talk about is when this shows up in case law and litigation. So I've done research on when Sharia shows up in U.S. courts, and this became a key trigger for the anti-Sharia movement. So I used to just say, here's how it shows up. It's usually in marriage cases, usually divorce cases. And then there was this, as we just heard earlier, 2010, you have this huge anti-Sharia movement that takes us, here's the topics. Those are the typical, I backed it up. The typical topics I used to say shows up when you're talking about whether there was a valid marriage, whether there was a valid divorce, and then this thing I'll talk about Mahara in a second. Then, there's so many charts that have been thrown at you guys today. I'm going to do the same thing. 2010-ish, there started to be this movement to propose and pass legislation. This is a chart that shows you the geographic depiction. Here's a chart in numbers. Starting in 2010, you have anti-Sharia bills proposed in many states in the country, and some of them passing. So these are states that have passed what are now called foreign law bans. They started out as actually anti-Sharia bans, and we heard in Oklahoma that was struck down because Sharia was specifically listed in the bill, which is unconstitutional to target a particular religion. So of course they rewrote it to be more neutral. And so it's the foreign law ban. Here's the actual language. You can read it as I'm talking. But we've had, they've been introduced in 42 states in 2010. In 2017 alone, 13 states introduced them, and then there was a handful, I think it's like 10 or 12 that have actually passed them. So this is a law that we're talking about, where this idea that if any state court any court that I'll just read it, or decision shall violate the public policy of the state if, so it is considered to be a violation of public policy if the court bases its rulings in whole or in part on any law, legal code, or system that would not grant the parties affected by the ruling the same fundamental liberties, rights, privileges granted under U.S. and state constitutions, including due process, freedom of religion, etc. When this first showed up, I was like, it's just a much ado about nothing. It's not doing anything. This U.S. law already does this, right? We already have a public policy protection if anyone tries to bring in some kind of rule from somewhere else that is somehow against public policy. And so I'll tell you a little bit more about the cases that showed up. I used to think it was, when it first showed up, I was like, this is just, as Dahlia said, to get people into the voting booth for other purposes and ginning up a lot of fear, but it really wasn't changing the law on the ground in any way. I was turned out to be wrong, and I'll tell you why later. But right now I'll tell you, basically overall, the cases show, going back as far as I could research, American judges neither automatically reject Sharia-based requests, nor do they automatically give it wholesale deference. There is a complicated combination of public policy and general constitutional principles that work through these judicial deliberations. Basically, in a nutshell, American law, state law, and federal law permit courts to consider religious law to the extent that it does not violate American public policy and also state public policy, and as long as the court is not engaging in some kind of doctrinal interpretation. They're not interested in the business of telling us what Islamic law means. But when somebody makes a claim, oh, Sharia lets me do this, and that thing that they're claiming is determined by the court to violate public policy, the court will then say, I'm sorry, I cannot accommodate that religious request, unlike accommodating a request for not to take an exam on Saturday, right? So for example, child custody in family law cases, never. There's very specific gendered and age-based rules in the fiqh, in the Sharia jurisprudence on child custody that the courts unilaterally, every time this comes up, have said, no, I'm sorry, we have a best interest of the child policy, and we cannot accommodate any other version of child custody. So it never wins a child custody case. Where it usually shows up is in these kinds of, was there actually a marriage? So you're in divorce cases, the question is, were they actually married in the first place? So you have different kinds of traditions and ceremonies that various communities will decide that they're married or not. So sometimes whether or not the couple is married becomes a legal issue. Whether or not the couple was actually divorced also becomes a legal issue. There are three types of divorce in fiqh, in Sharia jurisprudence. One of them is the most familiar to us, where the parties go to a third party, and it's kind of old school. You show grounds for divorce as opposed to a no contest. Like, these are the reasons for why I would like to get divorced, and it's usually the woman coming in. I'll explain why in a second. And then the judge, the qadi, will review and say, yes, according to my school. By the way, there's different schools of law that we heard earlier, and different schools will give you different grounds of divorce. But according to your school, yes, you have grounds for divorce. That's the one type, that's fasq. There's two other types that operate outside of a tribunal kind of situation, and you can already anticipate the problem. The court's trying to figure out what happened if it happened outside of a tribunal kind of adjudication. One of them is when the woman initiates it, and it happens with the consent of the husband, and they work out the details between themselves. So if there's kind of dissolution of assets or something, they're doing it on their own through mutual agreement. That one's called khul. The third one, which is probably the more famous, Muslims probably know of this one more common because it's more controversial, and that is talaq, which is the unilateral right of the husband to declare that the couple is divorced without consulting or consent of the wife under most interpretations. That raises eyebrows for courts because there's lots of situations where they want some kind of due process or a hearing involved in the decision to divorce. And so there have been some cases where the courts have had to evaluate whether that actually happened. The third category, the Mahara Recognition, I'll talk about in a second, but the Mahar itself is a term. If there's any Jewish Americans in the audience, you might be familiar with this. It's similar in classical halacha too. There's a particular item or thing of value that is a gift that is designated in the Muslim marriage contract from the groom to the bride that is a requirement of the Muslim marriage contract. It can be very low, but there has to be some reference to it. It can also be very high. And so it is, usually it's in the contract, and it becomes, usually it's payable at the time of the marriage, or sometimes they will defer to the moment of death or divorce. So often if it's very high, it's a deterrent for the husband doing this unilateral thing, because if it's like super high, then it's going to cost him. So this is a particular thing that often is if it's high, it becomes a big issue in the dissolution of assets of the couple, because it's in the Muslim marriage contract, but is it going to be part of the division of the house assets, for example? So those are the cases that usually show up. Let me give you some examples of some cases. It's kind of checkerboard. It depends. I mean, family law is dealt with in our state court, so it depends on the state and what they do. And different state judges seem to have different skill sets about understanding what this is. And I have a little sympathy for these judges, because they often are thrown with expert witnesses from both sides, and they're trying to figure this stuff out, and they don't understand it. And if you want to make a lot of money on the side, you can be an expert testament witness in these family law cases. Lots of money to be had to do this. Anyway, so there's a 1988 case. It's interesting. This is out of California, Variones versus Variones. So, what I was going to say was the cases they're checkerboard all over the place, and some do a better job of trying to understand what it is that the claimants are making, the argument, and then trying to do their best to accommodate it under American constitutional principles. But there has, sort of my sympathy to them is I watch them struggle and often stumble, sometimes pretty badly, at trying to really understand what this is. And it's really evidence in a lot of cases of this very confused lack of nuanced understanding of actually how Muslims live. So there's lots of cases that give you a really good sense of that. So I hope there'll be a little humor here, because I guess the Muslims might laugh along with me. So Variones versus Variones, 1988 in California. This is a situation where the couple entered into a marriage, but not in front of any kind of formal tribunal. It was done privately in a private setting. And so the court was trying to figure, and then they got divorced. The court was trying to figure out, were you married? How long were you married? And then they looked, among other things, it was basically common law marriage, putative marriage kind of questions. Did they behave as if they were married, right? So they looked at all the kinds of indicators of this couple's life to say that whether or not they had indicated they were married, and they concluded that they didn't. And I was surprised when I saw two factors that seemed to play a significant part. One of them was that the wife kept a separate bank account. All right, so Muslim women in the room know, what are you talking about, right? It is classical, across the board, all schools of law, that a woman's property is her property under the fiqh. There is no ownership of her property by her father, by her husband, by her brother, her inheritance, her income, it is hers. And it is quite common for a woman to keep a separate bank account, just to make sure that she's got her money where she wants to and nobody else is going to use it. So that is no indication that somebody doesn't think of themselves as married. And the other thing is she kept her own name. Also, not really a Muslim historical tradition to change your last name to be your husband's last name. In fact, you have lots of people saying that's actually a thing of women becoming property of their men, and we don't do that. That's a European thing, etc. So that's a weird thing to look at, but that's a first indicator of these not quite understanding Muslims, and they're trying to figure out, applying simple, basic concepts in American law, but kind of stumbling. What about whether or not there was a divorce? So typically, in the cases that are really the most complex are the ones where it happened overseas. And they're trying to, typically American courts will show comity to proceedings happening overseas if there is some kind of appreciation that's like basic due process is respected in those overseas. So it's just because a divorce happened by a court in another country doesn't automatically mean that an American court isn't going to recognize it. They just kind of look into it a little bit more to make sure. So basically they're looking for things, comity usually looks at due process, notice to both parties, fairness, an opportunity for both parties to be heard, and if everyone sort of knew what was going on. So now talaq is going to be a problem, right? Because talaq can happen with a husband just saying, I divorce you, and that's it. like, she doesn't get to contest it. There's no hearing, nothing. So what's happened is that when these talaq declarations happen in other countries, if they're done by some kind of additional proceedings required by the state itself. So if Pakistani law now requires not just a declaration, but some kind of a filing or recording or something, then it will get recognized by an American court typically, but if not, then it won't. So for example, Chaudhry versus Chaudhry, I don't have the year of this one, but this was the husband's divorce by talaq made at the Pakistani consulate in New York, so it's Pakistani territory. It was given comity because it was later confirmed that there was a proceeding in Pakistan where the wife had notice and an opportunity to be heard. So, okay, she was given fair notice. Whereas 2009 case, Tarikonda versus Pinjari, parties were married in India and moved to Michigan, and then the husband traveled to India, obtained a divorce talaq certificate in India somehow, and then the wife files for divorce in Michigan. It often happens, you're having multiple filings in different places. In this case, they did not recognize the talaq because they said, according to what happened in India, the wife was not afforded basic due process, she was not present in court, and there was no hearing. So that's what happens typically. There's some cases where a concern about talaq itself as a gendered thing has now showed up in public, not now, recently, this is a 2008 case I'm going to tell you about, that the idea that talaq itself is gendered has itself triggered a public policy concern by some of the courts that look at it. Again, this depends on the state. This is a Maryland court, Aleem versus Aleem in 2008. In this case, the talaq that was allowed in Pakistan was unenforceable in Maryland because, here's the interesting, not the specific proceedings for her, but it is more abstract. Being accessible only to men and not to women, talaq itself was against public policy under the Equal Rights Amendment of the Maryland Constitution. So the whole entire concept of talaq is gendered, and so therefore never going to recognize any talaq. By definition, they said it deprives women of due process that they would be entitled to in an American court. There is some sympathy in these cases for a situation of the mutual laws that we all live under. So we have our own sort of religious code of conduct, and then we have the state law that we live under. And often you're divorced in one, but not the other. This happens, anyone on the East Coast, in New York, in New Jersey, the judges deal with this all the time, of the limping marriage in the Jewish community, where the husband has absolute right to deliver a divorce, and the women are stuck. Like, I'm divorced according to civil law, but not according to Jewish law, I can't get married again. So the courts in some places seem to be sympathetic to this, and so there's some case law interesting out of Michigan where a judge looked at this, and it was the common practice for a while, and then they stopped based on this case, but recognizing that this judge was going to issue a divorce, but they asked the husband, have you given her a divorce? Have you talaqed her, right? And he refused to. He didn't want to. And the wife wanted him to say, I divorce you. She wanted to feel that she had been separated from him in the eyes of God so she could get on with her life, and he refused to do that. So while she was divorced by the Michigan court, she was not getting that. So the judge says, okay, I'm going to order additional spousal support that will continue, you have to pay her until you give her a divorce, a religious divorce. So you have to pay a little extra money, and therefore, and that's a little extra pressure to try to get it. They recognize they can't force him to give him that's a religious thing. They're not going to force him. And this apparently was sort of the practice in some of these cases. The judges sort of sympathizing with the situation of these women. In Hamut versus Hamud in 2012, the husband challenged this, and it went up to the Michigan appellate court, and they said that the appellate court said this is not okay to do that. And the ruling again reveals some very confused reasoning, in my opinion, about their understanding of Islam, Islamic law. So the appellate court of Michigan said that the court does not have the authority to compel, they recognize they can't compel the religious divorce, but they also can't do this extra spousal support thing. This, the court says, the implication of the ongoing award of spousal support was for an indefinite duration and was designed by the trial court to force or pressure the defendant to give an Islamic divorce, and that is improper. Why? Because it provides an incentive for the wife to avoid ending the religious marriage. If you're confused, join me in my confusion. The court says, as structured by the trial court, plaintiff, the woman, has no incentive to become self-sufficient or to vigorously pursue an Islamic divorce, as she is assured an ongoing income ad infinitum. I'm like, hang on a second. She wants the Islamic divorce. This is just trying to help her get the Islamic divorce. She was asking for this extra spousal. The court came up with this extra spousal support to try to force it. It shows a clear misunderstanding of what it is she's asking for, right? This is the thing he has control over. She has no control over that. Remember, there's the different types of divorce, right? She could go to a third party to get on grounds of divorce, or she could get her initiated divorce, but only with his consent, right? So it's possible that she was either concerned she didn't have grounds for divorce under a third party. It was a non-contest, it was a no contest kind of situation in America. Maybe her school didn't allow her grounds for divorce. The other thing is, oftentimes when the woman initiates, this is a matter of dispute within the schools of thought, but oftentimes when a woman initiates, she loses her mahar as a part of the analysis of the divorce. So if she initiates, so if she goes to a third party, tries to get that divorce, or she got him to consent, oftentimes giving up the mahar is kind of the way he consents. Anyway, but the way she's ensured her mahar is if he gives her a talaq. So she may not have wanted to use the third party option because she would maybe lose her money. I don't know the facts here, but the point is that, and the court seems to have been confused a little bit about this, because somewhere in the record there was this line: the plaintiff indicated that an agreement existed that would permit her brother and brother-in-law to authorize the Islamic divorce, potentially rendering it within the plaintiff's control to prolong her receipt of spousal support. So again, I think she probably could get like a third party through whatever this arrangement was that she was talking about with her brother and brother-in-law, but there are consequences to her initiating that are not consequences if he gives her a religious divorce. And so, again, the basic misunderstanding of the court is, though, the fact that she can get a third-party divorce doesn't mean that the husband can't get out of paying spousal support right now, because the unilateral is what talaq is. He wants to not pay spousal support. He can just say, I divorce you, end of story. Anyway, so that's the thing about confusion about mahar shows up a lot. And I think it's partly because it's seen through like a prism of a prenuptial agreement or something that we don't quite understand what the mahar is doing for Muslims. By the way, don't call it a prenuptial agreement if you're writing a marriage contract. That's lots of problems. Anyway, there are some cases where the court has, and by the way, this is a New Jersey case, so thank you, Dahlia, over there in New Jersey. Odatala versus Odatala, the court said, you know what, whatever the reason is that she wants this mahar, this is 2002, the fact that it comes from a religious belief shouldn't interfere with our ability to look at this as a contract, right? This is a contract, it's written down, you've got all the terms, offer, acceptance, etc. So the court actually says, why should a contract for the promise to pay money be less of a contract just because it was entered into at the time of an Islamic marriage ceremony? Clearly, this court can enforce so much of a contract as is not in contravention of established law or public policy. So that works in some courts. And so usually the litigation is just over, are the terms of the contract clear? And oftentimes, unfortunately, some of these boilerplate contracts that the mosques give out are very confusing. And so some of the litigation, I was like, I don't understand what this means. Ring, advance, and half of husband's possessions postpone. I don't know, postpone to when, what date? It was just, but that's typical, even Islamic contract law. Clear terms is a important feature. The courts tend to seem confused sometimes. There's some cases, California, an 88 case, described the mahar as a mechanism for the wife's profiteering by divorce. Therefore, it's against public policy. So this is the case where they didn't give her mahar for that reason. It facilitates divorce or separation by providing for a settlement only in the occasion of divorce. Wondering, 2003 case, again out of California, wondering if the amount of the mahar was enough to jeopardize the marriage, so not really understanding. Now, just to back up to the Islamic feminism conversation we had yesterday, there is a lot of really interesting literature, especially lately, about what is the mahar, right? Is it financial security in the event of a divorce for the wife? Is it a deterrent for the husband unilaterally divorcing her? Is it a form of compensation if you're unjustly divorced by your husband? Is it some kind of consideration, just thinking about basic contract terms for entering them? Is it simply a gift? And it's not clear because there's lots of debate over all of that. If it's a compensation for unjustified unilateral divorce by the husband, then what if the divorce is initiated by the woman? Well, then the argument of it being financial support and financial protection, why should it matter who initiates a divorce if it's just to protect her financially? If it's merely a gift, why does Islamic law treat it as a debt that is owed to her if he chooses not to pay it? If he dies or he owes debt, that if he dies, that's the first thing that's paid. So if it's just a gift, then why does it have all these extra contractual things? All of these are really good questions that happen within Muslim societies all the time. What is the role of this? How does it interact with laws about community property, no-fault divorce, etc.? Unfortunately, none of that conversation seems to be evident by the judges handling these cases. They're not aware of that. And now, even worse, back to the anti-Sharia slide. So, American judges now, I told you, they look at public policy when they're reviewing this, and usually they would go through the stuff that I just described to you. So sometimes they'd approve it, sometimes not. Now, and I said, I didn't think it was a big deal when this thing was passed. I thought it was obnoxious, but I didn't think it was going to change anything. Until this Kansas case, Soleimani versus Soleimani, where a wife's request to enforce her mahar was denied. It was denied because the court cited a Michigan case where the court had said things about the nature of talaq being gendered and unfair to women, right? So here's what the Kansas court in Soleimani 2012 says. Remember that line there about if any law or legal code that doesn't grant the parties the same due process, equality rights, right? So here's the thing. This is Kansas court talking. If the mahar agreement was the product of a legal system which is obnoxious to equal rights based on gender, a court could not become proxy to perpetuating such discrimination. So, because Sharia includes talaq, and talaq is gender unequal, therefore it qualifies as one of these foreign laws that does not preserve due process, freedom, equality for women, and therefore anything out of that Sharia, including her mahar, cannot be honored by the state court. And so this woman lost $650,000. Ironically, this law, and the court says, well, the law is passed to protect women. Sound familiar from the conversation we had earlier and yesterday about always protecting women, and we go to Afghanistan because we're protecting women? Anyway, all right. So when the bill was introduced, State Senator Susan Wagle told the Kansas legislature that it was a vote to protect women. The Kansas court, in this case, says enforcing the agreement would, if we enforced her mahar, we would abdicate the judiciary's role to protect such fundamental rights, a concern that was articulated in Senate Bill number 79. That is I don't think, if you ask Mrs. Soleimani how protected she felt after she lost $650,000, I don't think she thought that was exactly what's going on here. Even if the talaq is gendered and unfair, I don't understand why hold all of the fiqh rules hostage just because this one aspect is gender unequal. We don't do that in American law. I hope we don't do that in American law. If our voting laws are bad for women, do we also then deny them their property rights? Like, that doesn't make any sense. Maybe mahar itself is the counter to the unfair gendered nature of talaq. So why are you not enforcing the one thing that women actually have in this system to protect them? It's upside down. It's a little bit of ingrained Islamophobia. I also think it's a little bit of presumed superiority, that secular is always better. And the fact is, secular is not always better. I mentioned a few things about women's owning property. There are lots of things. I wrote for ISPU this thing about all the ways that if you looked at classical Islamic family law, it's actually better for women than certain aspects of secular law. Just begin from the position that a woman's property is her own property and nothing happens to change that. Many Muslim women are frustrated with community property, marital property laws because it's a surprise when they find out that actually what they thought was theirs turns out not to be theirs. My own divorce, I would have come out very differently if a qadi had adjudicated my divorce. I acquired the house with my own income. I paid I earned more than my husband. I would have owned the house and I wouldn't have had to split it. But because it was acquired during the marriage, he got half of it, right? So I was like, it's not always necessarily better to have some kind of secular law applied to your marriage, right? And so that's the thing, is that there is this presumption in the anti-Sharia movement and in general Islamophobia that Sharia is bad for women, definitionally against public policy, and anything that we do to protect women from this is good for women or good for overall rights. So the anti-Sharia advocates don't seem to think that the existing protections in our system, constitutional protections of public policy and due process, are enough. They want more, and they want to pass things like this. Motivated by some of the stuff Natana was talking about, they're worried that Sharia will take over American law. I hope we've debunked that. There is a basic rule that we follow the law of the land where we are, but also there's a concern that some kind of judicial accommodation of Muslim religious practices is somehow eroding our secular rule of law. And layered on that a lot of women, saving women thing. But I mean, I'm like, there are a lot of really interesting questions in these cases about the meaning and the scope of our free exercise clause, our establishment clause, individual rights versus religious freedom. We have a lot of interesting things that are in conflict in our society about when should all the law be the same for everybody and when should we allow people to opt out. So a lot of the rhetoric here and also in Canada with some of this stuff is like one law for all. This particular statute, this particular bill is written by this group called American Laws for American Courts, that there's some kind of uniformity as a goal, but federalism allows states to make different decisions. So there's some things in our society that we allow differences. And so slavery, at one point, we allowed the states to be different on, and then we decided, no, that's going to be the same for everybody, but we still allow states to have different rules about gambling. Depends what state you're in. So we have interesting questions about what do we all agree should be the same for everybody, and what are the things that we think are okay to let people opt out of? And the reality of religious minorities and other minorities in our country really brings up lots of really, really powerful questions about what is the role of religious law for citizens in a secular state? What kind of religious diversity do we think is good for society? Maybe even something we should enhance. And what part of it is destructive? These are really, really interesting questions, but they're not really about Sharia. They're about American constitutionalism. They're about who we are as an American secular society. And I think we really need to engage with those. And I think American Muslims have a lot to say about that. I think the LDS community has a lot to say about that. I would like to have conversations about that. Unfortunately, the anti-Sharia movement has derailed any possibility of that when it comes to Muslim cases in these family law courts. Last point, and then I'll close. After thinking about these cases for a long time, I started realizing that I was feeling more and more and more uncomfortable as I read the opinions. I was like, something is off here. And I realized it has something to do with how, even when they're trying to accommodate, how are they accommodating for Sharia and fiqh? They're getting it wrong so often, but what's going on? Why is their error so bothersome to me? And I think it's the lack of a nuanced understanding of how this would play out actually in a Muslim context. So if a qadi was doing this analysis, they wouldn't just be looking up the cases and the rules in a fiqh book and then slicing them off and then dropping them down in the cases. Qadis and muftis are required to tailor their rulings to each individual case based on the realities of the individual parties, understanding the culture, the reality, the economic concerns of each individual case. And so if the qadi was actually deciding this stuff, it wouldn't look like what it looks like when the expert witnesses are coming and saying, yep, that's the rule, that's how it goes, right? It's much more nuanced. That's not what it looks like here. There is like a hollow, like mechanical aspect to the way that the fiqh rules are depicted in American courts. It's often treated as like a static collection of legal rules that you just quote and apply regardless of context and circumstances. And I just think that that's just not how it works. That you don't just slice this off and drop it back down. So it was weird. I found myself like kind of agreeing with the anti-Sharia movement. Like, I don't want the courts doing this. They're not doing a very good job about it. So I don't know. I mean, well, there's lots of solutions to that. I don't have them all here now. There's a lot of things we could do. Maybe some of it is just understanding more about what Sharia means in American Muslim lives. A little bit more American Muslims going to law school, maybe. But it's a lot of education and understanding and awareness of actually what does Sharia mean in American Muslims' life every day. And I think that that is something we can all do. And this conference is a really good start to that, as many have said. And as the last speaker, I'd like to say, I think on behalf of all of us invited here, we have really, really enjoyed being a part of this conversation. And thank you so much for gathering us here. And thank you for the hospitality. And thanks to God for giving us all the ability in COVID to gather and spend time with each other. So thank you very much.